I have had an opportunity to look at regional recommendations, and I will only highlight some of them. Most of them are actually very good recommendations in the regions where, but we must always just realize that everything that we do, there are checks and balances. Some checks and balances comes from the Ministry of Finance that will come in and say that when we undertake to do this and that, do we have money to fund operational programs for all this? While some will be coming from the administrative side in terms of checks and balances, when you look at the recommendations against our Constitution. Let me start by saying, I think it was in the Truth and Reconciliation Commission in South Africa, it was around 1996, 1997, if I'm correct. During the hearing, public hearing, the chairperson of the commission, Desmond Tutu, required judges that served on the judiciary during the time of apartheid to come and explain themselves as to why couldn't they use the concept of justice, natural justice, couldn't use law and their power to interpret law in order to soften up and limit effect of apartheid laws during that time. Many of them were candid in a short presentation. They said, we failed to do what we were going to do. Some of them were actually very fed up with the invitation. They say we have no choice but to apply the laws as they were, whether they are unjust or unjust or just. We have no option but to apply the law as they were. Now, I mentioned this before I start making a short presentation on the regional recommendations, because when a society starts identifying things that matter to it, to its existence, the society starts identifying such issues, and if they find that such issues are compelling so that they become norms and values so that they deserve protection, then the society will move to things like law and policies to cement such norms and values, whether they are bad or good. In those difficult times before independence, both in South Africa, constitutional democracy, both in South Africa, in Namibia, what was identified as most important compelling issue, particularly by the white minority, was security of the minority. Yes, because they had power, they, through their apartheid laws, excluded the majority. They identified security and said, we must come up with laws and policies that protect our security as a minority. In that case, it was not land. Land was also protected, but most important, they didn't want black people to have power. So they used the law. In 1966-67, when Tate Kahumba Kandora, Toivo and others one would remember that there is an ordinary principle of law that you must not make laws that apply with retrospective effect. So in other words, if I have a property, and you come up with a law that all the property must become the state property, the presumption is that you are not talking about those of us that already have, you are talking about from today. Even those principles, when we discuss them, we must also discuss those principles about that you don't apply things in a reverse way. So now, in 1967 or 66, the apartheid government in South Africa introduced because they thought there is a problem here because black people are this movement of black consciousness. This Mandela movement in this is a modern history of liberation. They are bringing us problems. Let's introduce laws, some of them with retrospective effect. And that minority group, they internalized that there's nothing wrong with that because it's a problem. Blacks were becoming a problem. It's security. So let's come up with the laws. And they came up with laws that you can detain people without trials. You can detain people and deny them the right to a lawyer. Many of our liberation figures here, they have an inconvenience and discomfort of being subjected to that. But they have no choice because why it happened, why apartheid thrived for so long, it was because of absence of constitutional democracy. It was because of that. Now, as the time goes on, as land space become smaller, as the society become more radical, as resources become smaller, as government runs out of money because of many challenges, people will start identifying land as we have as one of the biggest problems. But unlike in South Africa as it was, our founding father moved fast at independence and got for us a constitutional legacy that effectively, sufficiently, and safely guarantee us checks and balances. So that today, when we have a pressing land conference, we do not get, with respect, out of control and do things that destroy us. That is the fundamental ratio behind Yatoivo, Neroro, Bessinger, Nico Bessinger, and others that have left already. They left after. They know that for the few years they stayed after independence, they left their grandchildren some protection. This is what the Attorney General was talking about, that we not retain. So with that in mind, let me talk about only a few recommendations. The communal land I spoke about yesterday, they need to be serious reforms. Particularly when development is very good, I don't think we should be obstructing when government, for good of all of us, want to develop towns and business hubs. We should not be obstructing. But if a person has land for over 70 years in a communal area, in fact, that person does not even know the concept of land registration or title. you come and you don't recognize that fact fully and meaningfully, informal. It says that. It is in my presentation. Because they are sensitive. I can guarantee you, given this process that the Minister of Land was going to give people some certificate in terms of the communal, the Ministry of Land or the other one, it doesn't matter. There are people who have not complied for many reasons. Some, they don't know how to write to complete those forms. Some information has not reached them. Some, they simply don't have money to travel where. So their entitlement to land is long-standing, has been, in terms of customary law, accepted, but because of the new regulations that are gazetted in the government gazette, they haven't complied. In South Africa, because of that sensitivity, they say informal or formal, people's rights must be taken care of in a just manner when you bring development. Recently, there was a case, I don't know the facts. I don't want to speak about cases because I don't know the facts. Maybe that this side was wrong, that side was wrong. But we hear cases where people are uprooted from them, and then only after negotiations start for you, whatever you are being compensated. Now you lost bargaining power because you are off your land. You don't have bargaining power. So there must be a serious, I suppose, a serious reform so that when people are moved, the law is there, obligating those that are involved to, in good faith, negotiate. But of course, the citizen must not become unreasonable at high prices. Just a fair compensation. That's one. The other recommendation that I wish to speak about on the issue of the claims I spoke about yesterday, but I just only one. If you look at the preamble, many of us, with respect, don't read it. I think that is the most important part of the Constitution. Because that is where the commitment, if you look at the last paragraph of the preamble, if you look at the last part of the preamble, if you accept that those who were led by Dr. Hage in crafting this constitution were elected by Namibian people during the elections of 1989, then it will follow that they were acting on a fair mandate by Namibian people. After they summer, in fact, it is so good. They say, for many years recognizing this and that, now that we have achieved our independence on this date and not wanting to revisit the past and not to be subjected to this, on behalf of the Namibian people, we adopt this constitution as a supreme. So in other words, they will say, so because the constitution is not there only to guide lawmaking, it is also there to guide our action. So that it is not only the law that is invalid if it is inconsistent with the Constitution, but our action too. If I stand up today here, I can tell you, and go to the High Court of Namibia, relying on Article 21, and demand that Mr. B or whoever, because he occupied land illegal, their sentence must be meted out. My action looked at against the Constitution clearly are unconstitutional. My pronouncement are unconstitutional. It may not necessarily be a crime, so to say, but definitely is an invitation of, because people are tired of crime. Many of our people have never read the Constitution. They think it's government that does not want to kill suspects. That's what they think. They don't understand constitutionalism, and it's our duty, those of us. And Comrade President, much of it, it's not actually law that is a problem of the regional population. We will see regional recommendation in towns. Many problems have something to do with accountability, good governance, and administration. But look at our political system. I'm not talking about the parties who are poor, I'm not talking about the opposition, I'm just talking about the whole political system. For us to do tangible reform, look at this regional recommendation, you can actually see. How many town councillors interrogate the issues identified by the regions and transform them in proper recommendations to the minister responsible to government? I can tell you without any fear, only fear. Why? Because the political system, through parties, a person that shoots very well, all of a sudden become a mayor. So we are frustrated, and this is understandable. It may not be the Constitution. It's the quality of people we are putting through the system. If election is coming next year, you will see everybody. But these are difficult to proceed. These are difficult questions to proceed. I heard people were even fighting to go to the land from the region. It's me that is going. But these are difficult questions to address. Therefore, those are my interventions.